This is in the District Court of Butler County, Kansas, case entitled In the Matter of the Marriage of Kara Boyce and April Boyce, case number 2024 DM406. Both parties appear with their respective attorneys. Susan Locke appearing with the petitioner Kara, Jessica Levitt appearing with the respondent April. This matter comes before the court at this time for a scheduled pretrial conference. Ms. Locke, let me have you go first. And what is your current statement that you would make regarding the status of the two pending cases which are related here?
Yes, the agreement this morning to dismiss PFA. So we'll prepare a stipulation and then get over to Ms. Levitt this afternoon. We also agreed to a pretrial order for the domestic case, so the divorce case, pending a trial date today. I'll update that pretrial order and get it filed with the court this afternoon. It looks like we're not going to be able to resolve the financial aspects of the case absent a trial. I know there's a pending motion from opposing counsel to appraise the real estate. I'll let her take that up. The parties have agreed to attend mediation at Midland Mediation with Joy Marlin in advance of a trial. So there is some hope that we would resolve this outside of a trial, but today we are requesting that we set a trial date.
All right, Ms. Levitt.
Thank you, Judge. And I will tell the court that my motion was filed on Friday, so I'm not sure if the court is wanting arguments, so to speak, or just to set that for hearing as well. I will advise the court that we had issued discovery, and just so that the court is aware that some of this is coordinating with my client who has just recently left inpatient rehab and been in a position to actually work with me again, go into our issues, but also because of my calendaring. So I'll tell the court that we received discovery answers from the petitioner on June 30th. I was already scheduled to be out of the office July 1st through 4th. When I returned and began looking at those discovery issues, unexpectedly, my grandfather passed away, which took me back out of the office. When I returned from my family matters following my grandfather's death, it had come to my attention that in our discovery, there were some things that were not fully answered by the petitioner. A golden rule letter has been sent to Ms. Locke, which she and her client, she's told me they've already started to discuss and address. But in that, specifically as it relates to the motion that I have filed on Friday, is request as to the petitioner's position about the fair market value of the marital residence, and that answer was left blank. And there is no documentation regarding what the petitioner believes the fair market value of the residence is. When the parties purchased this residence, they undertook renovations on it. And so for the petitioner to have no answer in her discovery as to what she believes the value of the residence is, and to know that the home has been renovated since its last purchase price, and those are renovations that all occurred internally within the home, that property tax records wouldn't necessarily reflect, we filed a motion for an appraisal so that we could have an objective value as to the fair market value of the residence. It's a request that we have made exclusively at my client's expense. She's willing to pay for the total cost of the appraisal. We have spoken with Sun Group in El Dorado, who advises that they can have it done in 2 to 3 weeks. The reason for kind of the gap, so to speak, and them not picking an exact day is because we advised Sun Group. My client was not in the home, and due to a PFA, which now, of course, we've reached a resolution on this morning, but due to a PFA, she couldn't be at the home. So everything had to be coordinated with the petitioner, whose calendar I was, of course, not privy to. And so the petitioner objects to the home being appraised, is my understanding, because they've advised that they object to, that we couldn't agree on the motion. Which of course Ms. Locke can speak more specifically on that. But we believe, given the issues between discovery not having an answer on fair market value, knowing that there are renovation and how quickly Sun Group can do it anyway, and all of this being at cost to the respondent, that the appraisal should proceed. And then as to the pretrial, Judge, we are in agreement on Ms. Locke and I have exchanged. The only thing missing from it is the trial date. I agree with Ms. Locke on that. We do have an agreed order on that. And the PFA dismissal was agreed to over email, and I am just anticipating reviewing an order once Ms. Locke has the ability to actually draft that at some point today. So beyond that, everything Ms. Locke said, we are in complete agreement on.
All right, Ms. Locke, on the appraisal issue, what is your position?
Yes, sir. So I got the golden rule letter on Friday after our office had closed. The first opportunity this morning that I've had a chance to speak. We do have documentation. We need to be the value of the house. The house was premarital, so it was purchased. Sorry, at our office. It was purchased prior to the marriage, into the marriage. So for those reasons, I can get documentation. It was just an oversight on our part on the discovery responses. Regarding the motion, the court was very clear that all discovery needed to be issued May 30th of 2025. You said that in our last status conference. There's a reason why a motion for an appraisal couldn't have been filed at that time or sometime since our last hearing on May 2nd. So we were surprised to receive this motion on Friday, and now equally surprised to be taking it up on Monday morning. So I haven't had a chance to really formulate a response to the motion. I would be concerned about Sun Group having a formal appraisal within 2 to 3 weeks. That sounds to me like a desktop appraisal, which does not include going inside the home and inspecting any alleged improvements that have been made. So I don't know the context about the appraisal, but we are opposed to the appraisal. It's outside of the discovery deadlines that were set. We have not had a chance to supplement discovery, and it was just an oversight by our office. It sounds like this was saying once she got our that would have been.
All right, Ms. Locke, I just want to point out to you that you sound like you're underwater. I don't know what's wrong with your audio, but it's not coming through clear at all. So I understood most of what you said, but if there's anything you can do to adjust your audio to be a little bit more clear, please do so.
We're just having a lot of connectivity. Is that
Susie, sometimes turning your camera off helps.
okay? I was trying to say that Cox is down in our area, so we're having all sorts of connectivity issues. So I don't know where I left off, but the court said
let me interject here.
Sure.
There was a discovery request made that you didn't respond to regarding value of the real estate, which seems to be a fundamental issue. And it seems like a rather large oversight on your office's part not to respond to that particular inquiry that was made.
Your Honor, I don't know that we didn't respond. So I got this on Friday. I haven't had a chance to look through our file to see what discovery was sent over to opposing counsel and if it matches with their golden rule letter. There was about 5 emails worth of documents that were sent over. So I need time to comb through that to see if in fact it was an oversight. We do have values that my client and I have already talked through that should have gone over to opposing counsel.
Okay,
but again,
what is your client's position regarding current fair market value of the real estate? That should be something readily disclosable at this point.
Yes. Let me see. $132,400.
I heard 132.4. Is that correct?
That's right.
Okay. Are you satisfied with that amount, Ms. Levitt?
Your Honor, we believe it's low. It's higher than the property tax records reflect, but we believe it's still potentially low. And I do want to address that as it relates to Sun Group, what type of appraisal they could do. They said they could be out at the house and do a full appraisal in 2 to 3 weeks. It was dependent on everyone's scheduling, which we had to inform them we could not directly schedule because my client, until the PFA is dismissed, is not allowed marital residence.
Which wouldn't necessarily bar Sun Group from entering the residence pursuant to a court-ordered appraisal. All right, Ms. Levy, I think if you have the number, your client's not satisfied with it, let's resolve the issue through a formal appraisal, especially since Ms. Levitt's client's willing to bear the cost of it. The court will order that the appraisal be done. court approved Sun Group as the appraiser. And I don't think that this appraisal is going to delay the conducting of a trial in this case, which we're going to schedule today. Any objection to such appraisals is overruled. Counsel, looking at a trial date, how much further down the line do you think we need to set this, Ms. Levitt?
Your Honor, because the parties have agreed from a cost saving perspective that they do want to attempt mediation between the parties, and who we agreed to, which was Joy Marlin with Midland Mediation. Joy is very quick, but I still believe she'll need 4 weeks to do, because she'll first need time to coordinate with 2 individuals' calendars and get them in. But then if they reach an agreement, she'll need time to write a memorandum of understanding. So I would say that we need to put a trial date more than 30 days out. That puts us to at least mid-August. I will tell the court my calendar mid-August is kind of brutal from my having a full day available. So maybe end of August is where I first start to get actually truly available for a full day. I'm willing to move things around though, depending on Ms. Locke's schedule and what we're dealing with, and the court schedule too, of course, because obviously you have to have availability.
Counsel, the first date that I would offer is Tuesday, September 23.
I'm available, Your Honor.
I'm available, as is my client.
Very well. Court will set it, what I'll say is a tentative trial date at this point, Tuesday, September 23, starting at 9:00 a.m. in person, courtroom B, Butler County Judicial Center. Again, that is an in-person proceeding, Tuesday, September 23rd, starting at 9:00, which is presupposing that mediation is not successful, which I highly encourage the parties to try to reach their own resolution. Often the parties among themselves can reach a more fair agreement to both sides than what would be perceived when the court orders it. So good luck in that regard. The court not only approves, but encourages the mediation to take place just as soon as practicable under the circumstances, as a prelude to a trial date that we've got set for Tuesday, September 23 at 9:00. Counsel, if you reach a settlement in the case, you could advise the court. We could convert the September 23 hearing into a Zoom proceeding to avoid unnecessary travel if we're simply going to put your agreement on the record and have the divorce taken. So for now, it's an in-person trial proceeding. If there's any contested issues, Tuesday, September 23rd, 9:00 a.m. If it's still possible to include that date into the pretrial order, I would ask the preparer to please do so.
Your Honor, may I ask some clarifying questions on the appraisal?
You may.
Can it be ordered that that is released to both parties?
Yes.
Even though the respondent is paying?
Yes.
And also, are we using the date of the petition as the date of the appraisal?
Ms. Levitt, you wish to be heard on that issue?
Your Honor, I believe that valuing the residence, the date of the petition is fair. That's kind of the standard operating, is valuing all the assets, the date of the petition. I do think that I think there, Ms. Locke, you'll have to remind me, didn't we put a stipulation already in place anyway on that in the pretrial?
Yes, the date of
That's the
separation.
valuation date. Okay, I was gonna say, I think in fact, we've already stipulated to the valuation date for debts and assets anyway, so.
Yeah, I
All
just wanted to make sure it was in the order that went to Sun Group, so they knew.
Yes. Is there any reason to believe that there's been an unusual market change since this case was filed, Ms. Locke?
I mean, there's been some fluctuations in the market here in El Dorado locally that could impact the value of real estate for sure.
All right. Well, apparently there's already a stipulation regarding the appraisal date as to what date would be applied. And so the court will carry that rule across the board to the real estate appraisal as well. So that's not a contested issue, apparently. All right. Any other questions regarding the appraisal, Ms. Locke?
No, Your Honor.
All right. Ms. Levin, is there anything further from your perspective that we need to address today?
No, Your Honor.
How long will it take to actually submit an agreed pretrial order with whatever changes are necessary today to the court's signing queue?
I should have it after the hearing, Judge, as long as our internet is functional.
Okay. Well, good luck in that regard. All right, I'll look forward to receiving that within the next business day or so.
Judge,
Oh.
we just have in there that exhibits will be exchanged 7 days in advance. Is that sufficient for the court?
It is. And if you can get your exhibit notebooks to the court at approximately that same time frame, and of course to each other. All right, counsel, I'll just open up generally. Is there anything further that we need to address as part of these proceedings?
Not from the petitioner, Your Honor.
All right,
Nothing.
Ms.
from the
Levin, will you be drafting a separate appraisal order?
Yes, Judge, just because it was a separate filed motion and so that Ms. Locke doesn't have to significantly edit the
All
pretrial.
right. I think that's a good and practical approach. All right, I'll look forward to receiving that appraisal order as well in the very near future so we can get that process started. If there's nothing further at this time, then the voice matter will currently be in recess, and this meeting may be ended for all.